Here we go. It's late. Everyone's tired. It's day one. Happy hour's coming up. You got one session left, planning cross-examination. Anybody remember the first time you heard that song? It's the universal answer. That's the universe. And I love that people think they're so clever to say it. I've been getting that answer for years, okay? For me, I remembered exactly because I had just been by Record Bar. That's a store that became Trax back when we had records and CDs. These were these things you used to play music on. I had bought it. I'd gotten into the house, couldn't wait to tear it open. We didn't have them in our car, the ability to play these things or download them. Put them in. I remember that the entertainment center needed dusting. I remember that the dog was jumping at the back door, probably scared to death about what was going on. But I also remember these words. What do you see? Yes, that's right. A legal authority. Look at how much time my buddy spent in a courtroom. That's who wrote this song, okay? No, that's not why I'm telling you it's CLE, but yes, he did have a lot of legal training. Once showed up for a probation violation in the LA County Courthouse and hid in the stairwell and refused to come out. They debated whether they could bench warrant him for not coming to court. And his attorney said, he's here. He just hid in the courtroom, but he's at the courthouse. He responded to the address. Brilliant. Unfortunately, passed. But the reason I put it up there is the juxtaposition. Smelling like roses that somebody gave me for my birthday deathbed. I am smelling like the rose that somebody gave me because I'm dead and bloated. Two ideas that don't quite go together, but make a big impact when you put them together like that. And when you talk about planning your cross-examination, sometimes that's what you need to do. Consider the order that you put your questions together because it can lead to a real neat juxtaposition sometimes. I had to cross-examine a judge. Anybody got to do that? Yeah, that's not fun. A little nervous. She was the probate judge. My client was charged with elder neglect. She caretook for an elderly lady for a number of years, had moved her into her home, then they accused her of taking all this money. The probate judge moved the lady out of her house because of saying that my client was abusing her, taking all her money, those kind of things. So I put up the history of them living together, was crossing the judge by asking about the things that she had done, and you pulled the records on her, and you'd been supervising, she was living with her for like that, and then her family got involved, and they thought that her accounts were getting bled down. Is that right, Your Honor? Yes. And Your Honor, it's funny to say Your Honor when you're crossing, but the judge is on the bench, so you're saying it. And Your Honor, then you said that she needed to be moved. That's right. And so the victim lived with my client for 2.5 years. Is that right? That's right. And then you decided that my client was not safe for her to live with. That's right. So you ordered that she be moved. Is that right, Ron? That's right. And she was dead in 2.5 months. She looked at me and she said, yes, sir. Yeah, that juxtaposition. Great judge, she's still my friend, but she talks about how uncomfortable that moment is because you're just using something. So sometimes not just the question you ask, but the question you ask before sets up the question that you're going to ask later. So cross-examination. Do you like the cross-examination? Do you? Anybody like to? No. No. Why? Because you love cross-examination, okay? That's what I'm going to talk about. If you don't understand it, everybody, I shouldn't have put it up there. That's Brianna Stewart. You should have known. It says you have to love your sport. Your passion and your dedication can't be sometime. Can't be part-time or spare time. You've got to love cross-examination every time. That is the funnest thing we get to do as a lawyer, as defense attorneys. We get to do it a bunch. And if you don't believe me, believe God. Okay? I got to harken back to Judge Bob, because actually this comes from the Catholic version of the Bible. There's the 13th chapter of Daniel. It isn't in most of the Protestant versions. There's more chapters in the Catholic version. But if you look at it, it's the trial of Susanna. And Susanna got accused of a crime. Now what happened was some elders saw her. They liked her. They wanted to have sex with her. They told her, asked her to have sex. She said no. They said, if you don't, we're going to say that you had sex with us and you'll get in trouble because that's adultery. Somehow back then they didn't get in trouble. But regardless, that was what the trial was going to be on. This is what I call the earliest recorded motion for sequestration of witnesses. She was led to be executed. God stirred up the Holy Spirit in a young boy named Daniel, and he cried out, I am innocent of this woman's blood. Said, separate the two far from one another, and I will examine them. What did he just do? Sequestered the witnesses. Yeah. He said, now, tells the first one, if you were there, tell me under what tree you saw them together. Under the mastic tree, he answered. Daniel said, you're a fine line, will take it, cost you your head. There's a weird pun here if you could speak Aramaic, but I don't. Now then, the next witness, tell me under what tree you surprised them. It was under an oak tree. Uh-oh, got him, right? Because sequestered the witnesses and did the cross-examination. They rose up against him. Now walk through. She was being led to her capital case. After her sequestration and cross-examination, they condemned the witnesses. If at the end of your cross, they execute the witness, you've done okay. I give you a C, C+. All right, how does good cross look? It's a CLE. We've got to show this video.
Did you order the code red?
You don't have to answer that question.
I'll answer the question.
I love y'all.
You want answers?
Like
I think I'm entitled. You want answers? I want the truth. You can't handle the truth.
The truth is that doesn't happen. Okay? I don't care how good your cross is. Nobody's just going to confess up there on the stand to that happen. All right? That's what the truth is. The truth is a lot of cross is preparation, a lot of cross is boring, and a lot of cross is work. Plain and simple. When does it begin? All right? I know some of you said, Phil, we've listened to you way too much. You've said some stupid stuff, but this is the dumbest. All right, it begins after the state's direct examination when you're recognized by the court, right? Duh. No. I think it begins a little bit before that. Well, okay, during direct examination, that's when you're cross because you're kind of getting your ideas and your things like that get ready. That makes sense. A little before that. During opening, because you heard what the state was saying that they're going to start doing, so that's what's going to kind of shape some of this stuff for your cross. Let's go back a little further. How about when you interviewed a witness, right? When you started seeing what the case was about, is that when you're crossing? How about when you met your client? First time, be it at the jail or in your office or wherever it was, initial appearance date. Is that when your crosses start beginning for how, let's go back a little bit further. How about when you first got the file? Discovery, when you read through it. Did you start thinking about, what if this might be? That's good. How about when you first view the scene? And you will view the scene for every case. I don't care how many times you've been to that Walmart. You need to go back and see it again under the perspective of the case that you're trying there. Or how about this? When the alleged crime's allegedly committed. We're going all the way back. Well, how about this? When the witness was born, all right? That's close enough. I think you need to look at their parents a little bit, but that's where you can gain information for your cross. Sources. So that's what we're talking about, the materials. What's good? It's all good, potentially. Anything you can get. Next time they give you a stack of Discovery this high, well, whatever high, don't say, oh no, say yes. There might be something good in there somewhere. Read every page of that because something's good. This statement, let's look at it. On July 4th, 2016, I was at the party at Flintbrook Lane. I heard some gunshots. I don't know who was shooting. I don't know who got shot. I don't know who was at the party. I was trying to run away and got stopped by officers. I don't know anything else. I don't want to testify. Is that any good? Oh, that's beautiful. Why? Yeah, and if this person shows up on the stand, all of a sudden is identifying your client, what do you have? You got cross, baby, and God's getting ready to execute somebody in the form of you with this cross. Yes? Yes. This is the fun. All right? This. Facebook page, look up a witness on Facebook who then hits a stand and say, no, I'm scared of guns. It scared me to death. Really? Now are you? Yes, it's all good. And view the scene. I showed you one scene from A Few Good Men. Everybody thinks is the climax. No. This is the pivotal point of the movie. This is what matters. Those of you that are over 40, whatever it is, and know this movie, what's happening right here?
Say we should make sure somebody gets this to his parents. We don't need
Viewing the scene.
Right.
Realizing, uh-oh, that dude's not packed. If he was going to be on a plane at 5 in the morning, he would have been packed. Something's wrong here. Now, if he hadn't viewed the scene, he wouldn't have gotten to meet Jack Nicholson. You on that wall. Yeah. But going to the scene is what gave him that information. And that is what cross is. Gaining information. Then during testimony, you got to take notes. And I'm not going to tell you, who was it called? John called my writing serial killer writing today, right? Okay. That is that's gentle. That's kind writing. That's beautiful. I'm not going to tell you which way to do it. For me, I do the line, okay? The left 2/3 are just me taking notes. The right 1/3 is stuff for crossing, and I circle things for closing, okay? That's just for me. That's how I do my notes while I'm doing trial. But you have to listen, and you have to take notes, okay? Because you will forget things. You need to do it. Next, if you've got material, will it work? Well, maybe. Emory Buckner says, more cross-examinations are suicidal than homicidal. There are two reasons for that. It's a mistake in the conception as the function of cross-examination and a faulty technique. Okay? So you may have the materials, but it may not work. There could be a problem. Because anything you do on cross, every question you ask should do one of two things. Advance your case or erode theirs. You do have a case theory, right? We need to start there, I guess, before we get to this. But yeah, you've got to have a case theory, and every question on cross should work toward that. What's some techniques that'll work? Attack, attack, attack. No big MMA fan anyway. This was an MMA fighter who that was sort of his fight plan, and he ended up getting pretty injured from it. But if you've got a theory, you can't just attack, 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 all right? No, you get what you can get. What I mean by that. All right, it would be fun if it could end that way. It would be fun if you could have crowds cheering you as you walked into cross, but it's not. Cross is going to be hard. You got to ask questions that are just trying to get one simple thing. The sort of hard work that Melissa made fun of at the presentation this morning. All right? Use a plain declarative sentence and only add one new fact per question. Plain declarative sentence. That doesn't even sound like a question, does it? Nope. Only becomes a question because I put a question mark at the end of it. Some judges will fight you over it sometime. But if it's about 12:30 and I look down at my watch and I say, you want lunch? Is that a question? Yeah, it's a question. But it's me giving a statement, you saying yes. And that's what we want cross-examination to be. Grant does 102, talks about Irvin Younger's 10 Commandments. Keep it brief, keep it simple, be prepared, listen. Or some people like to use Terrence McCarthy. Larry Posner came and spoke to the conference 2 years ago, if you got to see him, or Roger Dodd from Georgia. All these techniques, wonderful books talk about what to do, but basically they say some simple rules. First, ask only leading questions. Why? Yeah. You get to. That's the advantage you got. Use it. Establish only one fact per question. One. Judge Bob used to get so mad at me because when we struggled with that in my group, I did an exercise with Mary Had a Little Lamb, making you ask only one fact per question. He hated it. But yes, only one. Because if you ask more than one, you don't know what they're answering to. 3, ensure that each question leads to a goal. Please don't just repeat direct. Okay? Because all you're doing then is proving the state's case. And Chekhov's gun, If a gun appears in Act 1, it better be used in Act 3. There's got to be some reason you're trying to get to this. Otherwise, take it out of your cross. Okay? Cross doesn't need to be long, it needs to be good. Think of cross-examination as a series of statements by a lawyer, only occasionally interrupted by a yes from the witness. That's cross. If you don't think it could work in real life, here's the fellow.
Good afternoon, Ms. Mercer.
Good afternoon,
My
sir.
name is Roy Black. I represent Mr. Smith.
I'm aware of that.
Your friend says that she was raped, is that right?
Yes,
What she tells you is that she wants her shoes. Is that correct?
yes,
So you went into the house, is that correct?
yes,
Into the house where the rapist is, right?
I guess you could say that, yes,
You get to a dark stairway, isn't that correct?
yes,
There are no lights in that stairway, is there?
no,
You go down this stairway, right?
right,
With this man.
right,
You and this man who's the alleged rapist go out the door, is that correct?
right,
Out onto the beach.
right,
And you then spend several minutes looking for these shoes with this man who's the alleged rapist. Is that right?
right,
Then after a while you say, well, let's forget about looking for the shoes and let's go back.
right,
Is that correct?
right,
Going up the stairs, this man who's alleged to be a rapist is behind you in this dark stairway. Is that correct?
right,
The two of you go up the stairway. Isn't that right?
right.
What do you hear? She like him? Does she want to help him? Why is she? Yeah. What else do you hear? What has he done before today? When did his cross start? Yeah. Feels like it, doesn't it? Has he been to that scene? Heck yeah. He's walked those steps. He's seen where it's dark. He's seen where there's lights and all that. Look at the cross.
Now, there's one thing you forgot to tell us in that scenario on direct examination. What you said to this man who's the alleged rapist when you left. You forgot about that, didn't you?
I wasn't asked that, sir.
Didn't you tell him you were sorry?
No, I did not.
Oh, didn't you tell him, Miss Mercer, that you were sorry that you had to meet under these circumstances?
I used those words.
I didn't
yes.
ask you why you used them. I said, did you say you were sorry you had met him under those circumstances?
I did not mean I was sorry.
I didn't ask you what you meant.
Objection, she's not being allowed to answer the question.
Overruled. Please answer the question.
The question is, did you say to this man, I'm sorry we met under these circumstances?
Yes, I said that.
To the man who's supposedly the rapist, is that right?
Yes,
The man who raped your friend, right?
yes,
Your friend.
All right, if that objection occurs early on in a sloppy cross, I guarantee you the judge sustains it. But if you can stand up there and do an efficient cross, do it correctly, you got a chance of winning that objection did there. I mean, this is a
Now you received.
great cross. It's the William Kennedy Smith trial, by the way, happened decades ago.
The following day,
Black
Black
women.
brings forward a vase
I'll
taken
just
from
show
the
you
Kennedy
this.
home that night and
Remember we
places it
talked
in
about
front of the
using some of
witness.
their evidence?
Mercer claimed her boyfriend, Chuck Desiderio, took it that night to prove that they were at the estate.
Are you aware that only your fingerprints are found on the urn?
I had read that, and I assume that's because I had given it to the police.
But Chuck's fingerprints are not on the urn, are they?
That is
I mean,
very odd to me.
you have any idea why Chuck's prints were?
Okay, and we'll pause there because he's asking an open-ended question, which I'm going to normally say you shouldn't do. Do you have any idea why his fingerprints are there? But there, he probably doesn't care what that answer is. Oh, and by the way, as an aside, he left that dang vase up in front of her when he finished, and the stupid prosecutor did the rest of direct with the vase sitting in front of their witness when they're testifying from the stand. So cross will let you take over control of the courtroom. But what the training says, never ask a question on cross-examination unless, in the first place, you know what the answer would be. But make sure you really know what the answer would be, because sometimes we think we know.
Hi. Hi. I'm Dr. Calder. You've been charged with 1 count of murder and found incompetent to stand trial.
She had a demon in her for a while. My neighbor, Mrs. Karsh, it would come and go. Nobody saw it except me.
What did it look like? The demon.
Did you ever see Alien with Sigourney Weaver?
It looked like a giant insect.
No. It looked like Sigourney Weaver.
Sometimes you may not know what the answer actually is, or if in the second part you don't care what the answer is. Now, Lisa's smiling at me because she's great at jumping in and winning a lot of crosses. If y'all haven't gotten to talk to Lisa Collins, please at some point talk to her. She was a prosecutor with me. She's been a defense attorney with me and against me. We've fought, a great resource that we now have, so please talk to her. She'll get off script a little more, but there's a lot of training and a lot of work behind it that does it. I, on the other hand, have learned a lesson not to do it. And here's what I mean. I was a prosecutor at some point in my life, and we had a new attorney, who is now a judge also, who came and asked me to help on a case. And I was like, well, let me look through your cases. And she had a DUI as a young prosecutor. This DUI had 3 lay witnesses, okay? I was like, oh, that's great. The first lay witness was the person who was at the, he was at filling up at a convenience store, okay, who calls 911 and says, there's a drunk guy up here filling his car up. Y'all need to get somebody out here and stop him. The second lay witness is the employee inside that he goes in and starts hitting on, is drunk at the counter. She calls 911 and says there's a problem. The third lay witness was a fellow named Eddie Shipton, who ran a sort of questionable bar out on the outskirts of the county, who called and wouldn't serve him. And I never knew Eddie Shipton not to serve anybody. And he said, no, you called the police, said y'all need to get him. 3 lay witnesses. So she's talking about, I don't know if this is a good guy. I'm like, what are you talking about? That's the best DUI case I've ever seen. 3 lay witnesses. I don't need to rely on science or officers or anything like that. So we're going to try the case, and she says to me, well, Phil, I don't know. We go to the meeting. Anybody got any cases? I was like, this person does, whatever. And she says, well, it hadn't been to the grand jury yet. I said, they meet Thursday. She says, well, we don't know what'll happen. I said, it's York County, rubber stamp. Anyway, there's an inside joke there. Not so inside, but yeah, okay. Woo! All right, so she said, all right, well, will you do the cross-examination? I said, well, I'd do it. I would pay for this cross-examination. Okay, pay to cross-examine this guy. So he's up there on the stand. I've told this is the greatest thing trying this case. I'm the prosecutor, cross-examine. I go in there and ask him, and he goes through stuff, and their defense is that he drank once he got home. Okay, he got home and he popped, did 40 and drank and all that sort of stuff. So I'm cross-examining him, and I start out with a question, and I say, why do you drink? Now, it's open-ended. Technically, I probably shouldn't do it, but can he hurt me with that answer as the prosecutor? Probably not, right? And he says, be honest with you, Bo, makes me a little looser with the ladies. And I'm like, oh, that's gold, right? Because what do I have? I got him with the cashier at the convenience store, right, hitting on her at the thing when she calls the police. Golden, okay? Do I get out there? No, because I'm former PD. I'm now a prosecutor. I'm Superman of Cross here. I'm going to go do it. I'm going, all right. Well, I don't understand. I said, when you testified earlier, you said there was nobody at home with you. He got the dog, so, huh? I said, you testified earlier, and you said that when you drank that you were home alone. He was like, yeah. And I said, but you said you drank to make yourself looser with the ladies. There weren't any ladies with you there at home, were they? Now, should I have asked that question? No, I should have shut up. I had everything that I needed for closing already. You know what happens next? He says, front witness stand, comes up here, he says, yeah, but I said I was making a sandwich. Right, that's the look I had. That's exactly what I did. I looked confused. I was like, hey, what? And he says, everybody knows beer goes good with tuna fish. And a juror says, that's true. And I lost the best DUI case I have ever seen because I asked too many questions. Asked a question I didn't need to ask. for whatever reason. What if the witness doesn't answer the question? Control techniques. What works? Well, you got to remember, cross-examination is not a fair fight. Okay? It shouldn't be a fair fight. And you shouldn't be bothered that it's not a fair fight. You get to ask all the questions. You get to control the pace. You should always win. Don't feel bad about winning in cross-examination. It's what you ought to do. What techniques work? Well, I'm going to show you the superpowers. That is not exactly superpower. But you would be amazed how much just doing that will stop somebody. They start running on an answer they want to answer everyone else, you just stop. I don't know what it is. Mother used to do it to us or whatever, but that'll work. What type verbal techniques can work? Well, when you get runaway witnesses, it just...
Wait a second. Any of the things you're saying all Muslims... Wait a second. Things, and you painting the whole group religion with that. No, let's...
Anybody get any of that? That's what happens if you don't control your witness. That's what it looks like to a jury if you're not controlling them. Techniques that don't work. Some movies do this. Just answer my question, yes or no. Right? No. That's horrible, okay? Judges might not permit it. Juries will think that you're not playing fair and that you're trying to trick or put words in their mouth. How about this one? Asking the judge for help. Your Honor, they won't answer my question. They're being mean to me. Can you help me? No, don't. You control this courtroom. Don't ever ask a judge for help. All right? Yeah, because if you ask a judge for help, then a witness is going to think they can ask a judge for help too, and that judge might get some help, and that witness might get some help from the judge. What if the judge answers this? I'll permit the witness to give a full and complete explanation if the witness thinks that the explanation is necessary for a complete answer. That wasn't good. Or how about this? You asked the question, counselor. Now let them answer. Or even worse, I think the witness is answering the question. Yeah, that isn't what you want. Nonverbal techniques that work. Keep eye contact. Always keep your eyes on the witness. If you start looking at somebody, it is horribly uncomfortable if you just stare at them. Because they really get uncomfortable. And they're thinking, like, he can't give the rest of this whole lecture just looking at me, can he? And you think, well, now, whatever, and yeah, but he will. He'll just sit here, and you're like, he is a jerk, but I didn't realize. And now, see, I want to look away, but I still don't look away. Because, look, now, will she help you? She can't help you because this is uncomfortable for you. There is no judge. Oh, you think that it's not you think she felt that. It's more than empathy now because, yeah, look down. I know it's terrible. That's the power you have. That's the control if you use it. But if you get stuck to your little notes, you've just given that away. And look, what they both did. When I walked away, look, relief. Yes, you'll see them. They'll get bolder if you then look down because they see that they've got you at that point. By having your eyes fixed on a witness, it's a nonverbal communication, a declaration that you won't put up with nonsense. If you don't believe me, believe Doc Holliday.
Why, Johnny Ringo, you look like somebody just walked over your grave.
Look at what they show. Eyes, eyes, eyes.
Say when.
Shot beautifully. Yeah, there's guns around, but what really matters are the eyes, and that's the control technique you can have that really works. Techniques that work, verbal techniques. Ask, repeat, repeat. Question, car was blue. Witness, I couldn't really see, I'm sure. The car was blue. Well, it might have been kind of gray. The car was blue. Yeah, normally by that third time you just get that yes, that just kind of magic. Or if that doesn't work, ask, repeat, reverse. State's Exhibit 15, your statement to the police. Yes, you signed it. Well, I can't remember, it was a long time ago. You signed it. Well, I'm not sure. You didn't sign it? And there you get the, huh? Yeah, because they know they signed it, Right, someone else signed it? Well, no, I mean, I signed it, but okay, good, you signed it. Repeating the question, the polite form. You shot John. Blah, 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 blah. You shot John. Blah, 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 blah. I'm sorry. That last question may have confused you. Let's try it again. Or maybe my last question was unclear. Let's start over. You shot John. Now, they're going to try to concede that you shot John is too confusing a question. All right, does this really work in real life? Well, if you get an I can't remember witness. Here's a transcript I'm going to show you. What does that mean? See the back. No. I just paid for a transcript on my own, out of my own pocket. I wasn't relying on, of course I lost. That's why there's a transcript. Okay. Anyway, armed robbery case. I got to try it. It hung, so I'm retrying it. Okay. Pre-trial motions, I crossed this witness. At trial, I crossed this witness. Pre-trial is second trial, cross this witness. This is a transcript of it. Pre-trial second time. This is trial the second time. This is the fourth time I've cross-examined this witness. I know what she's going to say, right? I've been through a description with her. Mrs. Crane, let me clarify. That night you didn't identify Mr. Heath. Is that right? Is that a good question? No, Phil, that's a bunch of pre-ramble foolishness. It should have been one declarative statement. You're correct. That's terrible. All right. But I go through with her. All I want to get to is that the description that she gave wasn't good. So I get all the way down to the bottom. Did you give a description that night of the police, either individual that you saw? She said, I don't recall. She's never said, I don't recall. I've crossed her 3 other times. She didn't say, I don't recall. All right. For every witness, every question I ask, I have source data for it written out to the side, showing me where I have a basis for that question. I keep it in my impeachment thing, and it's in a notebook. You know where I keep it? Right here where I'm asking the witness the questions. Nope. It stays way back over there at counsel table. You know why? Because when I get an answer like this, we make this slow, painful walk all the way back over here to the statement. It's so hard to get all the way back over here to this big book that I'm about to open up. And it is red. And then you got to make that big popping noise, right? When you open it, pop, just so they'll know. And you look in there, and I know I've got her statement, okay? In my trial notebook, I've got the cross for each, followed by their statements, and I keep the cross with me. I have her statement here. So I go through with her statement. I know that she signed it. I know I've been through it, and I know that she said inside, and this is the only description she gave. I saw 2 black males holding Neil up. One black male was wearing a black shirt, dark-colored pants. The other guy was wearing a white shirt and jeans, not sure of the color. I was seated in my car. So that's it. 2 description there. One wearing a black shirt, black jeans, not sure of the color. At some point, did you give a signed statement? It's in my hand. Remember, I already walked all the way back over here, big hair, bop, statement in my hand. Mr. Smith looks at the witness expectantly. She doesn't budge. She don't want to touch it. Because I know what it says and she knows what it says, right? At this point, I look down at the statement, begin to hand it to her. She won't touch it. What does she say? Yes, sir. Yes, sir. Yes, sir. No, sir.
Wow, winning.
Yes. That's what you do by presentation, because that cross starts so far back beforehand. Now, that one was easier. I'd been through it a number of times with her, but you never know when it's going to pop up. Just because you think you know a witness, you may not. I got to let y'all go. We got to go playing cross. Thanks.